from your original position in the House, the Speaker versus the House case? What actually did you dissent? Question.
All right. If the chair will allow me to answer that, I will. I have said, beside law, ordinary English, when you declare something, you put period. You don't put exclamation mark. The law says that one can only revert to the Supreme Court when the Supreme Court gets opinion. If the Supreme Court gets Monday, and that Monday was not enforced or it being enforced irregularly, that's the only way you can come to the Supreme Court. The issue that was before all was in Reed. In Reed is a declaratory judgment. We declared a right for two sides. One side decided to come back to us on bail of information. That was an improper way of coming back to us. Assuming that that right we declared was violated, that party has the opportunity to go to the court below. Court below will take evidence, who violated it, when it was violated, how it was violated, then the appeal will come to us.
Mr. Lamini,
yeah.
The matter in question, did it go before the lower court?
No.
Then how was the party expected to go before the lower court?
The right has been declared. If you read my dissent, I'll give you an example. In 2020, there was a Lebanese fellow from Liberia who went to the ECOWAS and took $12 million. He came here to do business with. He may use the money. The issue came to us through declaratory judgment. We declared the right. We gave order that the money should be paid back. We were brought back to attention by the lawyer that declaratory judgment does not give order. Therefore, you cannot. We conceded and we send the party back to go and file the appropriate action. As we speak, the matter is before the Convention Court. ECOWAS court just testified. So we are correcting ourselves that declaratory judgment has no enforcement power. How then can we now, in less than 3 years, come back and get declaratory judgment as enforcement power? That was what I'm talking about. So it's not the merit of whoever are coming to us, the merit of it. The question is you cannot come to this court on bail of information when we did not give mandate to the court below. And there was no mandate. There was no contradiction. And I'm saying that if they build a house and somebody let the door and coming through the window, that's what we're talking about.
So what did you declare ultra-virus when you agree with the majority opinion on December 6th?
I'm sorry to say that I don't understand me. We said, Kofa and his group, you are a minority group, you are the senator, and you are the speaker, you are recognized, but you cannot proceed without a quorum. This one in the group, we know you are a majority, but you cannot do anything without a speaker. Both rights were declared. Assuming that Kofa believed that that right was declared was being violated, he was not to come back to on violation on bail information because the law says you cannot come back bail because we did not send any money below.
In fact, you did not declare anything on December 6th. You only explained.
We declare on December 6th that you are the speaker, but you cannot proceed because you don't have a quorum and you didn't give up any rule, and there is no law as to how you can get quorum to come to. We declare that. It's
So in your view, 4 members of the bench flipped.
Oh yes.
Okay.
That's the decision I sent back up to today.
Okay. Let's proceed, sir. When you came for your confirmation, I was concerned about this thing about injunction and prohibition. It was my view then, still is, that the court may be a contributing factor to some of the disputes in the country because the way it handles injunction and sometimes prohibition. For instance, it takes the Supreme Court almost forever to hand down rulings in some matter that is before it for prohibition. The government's agenda is to fight corruption. And if, for instance, one matter goes before the Supreme Court on prohibition in the fight against corruption, the Supreme Court takes about 9 months to hear such a writ, which they could hear and then allow the lower court to proceed. A case in reference, the arrest, the assets recovery and case and gracious right. It took the Supreme Court 9 months to hand down ruling on a writ of prohibition, whether the lower court can proceed or not to proceed, or whether the asset recovery institution can proceed or not. Don't you think that this delay, in my view, is in breach of the spirit of the Constitution that talks about fair, impartial, and speedy trial? Question.
Well, in the first place, I don't think so. I don't believe so. One has to understand how the Supreme Court works. When the matter is on trial in the court below, and the party chooses to go to the justice in chamber on prohibition, certiorari, or any other remedial writ, the law says the justice in chamber has the right to call a conference and determine whether there is a reason to issue the writ. By the time the justice issues a conference and determine that there is magnitude to issue the writ is issued, the party has to be served and given time to file their return. And when the return is filed, the party given time to come to what they call argument. When argument is made, the justice has to rule. And when the justice rules, the party has the right to appeal before the full bench. Before you go through that process, maybe 1 or 2 months would have passed already. And when the case enters the full bench, the bench is not under duty to hear it that time, because case entering the full bench is targeted for the following term. So the bench will not come back to that case to hear it. Obviously, no matter how urgent it is, the court is under duty to target it for the following term. By the time the following term, what we do is we take all the motions that are on the calendar, we say we deal with first, we deal with all bill and information first, then we go to ruling coming from the chamber. So that is the process. That process is laid down by the rule. Except you, the representative and senator, decide to change it. That's the rule, that rule works with. So it doesn't contribute,
You made a rule. The judiciary, through your judicial canon, made a rule. So do you think, in the spirit of reform, do you think the legislature should take up a reform issue like setting timelines for how long motion issues can stay before a judge?
Thank you, Senator.
Yeah.
If I'm convinced that one thing I intend to do, our law has so many irrelevant portions, so many active ruling or statutes that have no relevance to us. So we need to have a committee between you and ourselves, so we are the end user of the law, to say these particular things are wasting our whole time. We need to remove them. But we cannot do it ourselves, but we are not lawmakers.
The issue about land dispute,
Yeah.
which is a serious problem. I'm also convinced that the court is a contributing factor. And how do I mean? The probate court will probate a parcel of land on Paranville Road, a particular spot. Somebody else will carry deed for that very particular spot, and the probate court will probate it too. Then another person will come bring land deed with a meets and bounds from that very particular place, and that very probate court will probate it. What do you think we can do to mitigate this? Because if the court is a place to resolve crisis or dispute, and the court is a contributing factor, what do we do?
Well, firstly, Senator, when these are taken to the probate court for provision, that judge is not a technician. He's not a surveyor. He may not even know where the deed is coming from. All that is required is he should placard that deed within 3 days time to see if anybody has objection. If that is applied to, is applied by, and that nobody raised objection, you just go ahead and probate it. He may not know the location of the land. So if somebody brings subsequently, how do you expect the judge to know? This is part of our fundamental problem as a country. For instance, in other countries, when you buy a piece of land in Montreal County, the person who got that land will bring the original deed. And that original deed, the court will, whoever is buying the land from, the land administrator or whatever in that district, will cut that portion off and cross it out and issue new deed to him as a remaining land. But that policy has never existed in Nigeria. So it makes our land issue complex. Everywhere in the whole country is complex that way. So the judge who is sitting in that court does not have that technical know-how to know the particular land, the particular one line, the particular location of Nima kind of Broncan or whatever is the one that he brought in for. All you know, you comply with the rule of the law that says, put it on the go, let somebody see who our objection, let him raise it. If you raise that objection, then you will pack out here, then the judge will go into the final.
Mr. Domini, don't you think the court also has a duty of care? For instance, if we're looking at the future of reform to reduce and mitigate some of these things, there are actions the court can take. If you digitalize that area and have a database, and somebody brought one land and it is in that database, mixed and bound, the next day another person brings a deed and they put it in that system, it will pop up. Oh yeah, that reform, that's the way to make progress. But when you say the judge can do anything, the court can do anything, it means, sorry, 1 minute. Yeah. Then it suggests to me that there is no plan and no vision for reform. Yes.
The duty of care that the court has must be within the framework of the law. You must pass the law. The law that you have passed so far that control the public could say when the deed is brought to you, placate it and make sure that there is no objection. Now the question of digitalizing, you need to provide the money. We have just started the process. If you follow our strategic plan,
no, so that get what is there. I mean, you want us to fund the digitalization, or you want us to make new law to take the digitalization? Because from your response is that we must pass law. I'm saying that reform action there. It doesn't require law.
No, I'm not saying require law.
You say we should pass a law to do that.
I say what we want is whatever we are doing now, it must be within the framework of the law. Your first question to me, you're going to have a duty. I said we have a duty, but that duty must fall within the framework of the law. We should not do anything that is not within the law. What the law is now, that what we are doing. But as a question of this, I agree with you. But it requires funds. That's the reason why our strategic 5-year planning fund care digitalization. But we need the money to be able to do it.
Mr. Chairman, I yield for now with the opportunity to return.